Hello, thank you very much. My name's Chris Smith. I've been a commercial barrister at Quadrant Chambers for about 20 years. My QBiT talk is how to cross-examine a witness. Now, cross-examination is both the most terrifying and the most fun thing you could do as an advocate. It's terrifying because there is no greater scope for being stumped or looking stupid in court or before a tribunal, but it's so much fun because there is no feeling quite like getting an answer to a question when you've really worked for it and earned it. I know we're all meant to keep a poker face when that happens, but the temptation to grin like a schoolboy is almost impossible to repress. The aim of tonight's talk is to get you hopefully into grinning territory rather than wanting the ground to swallow you up. Now, what is the key to a good cross-examination? Preparation. I know, it's not sexy. It's not like saying, eat lots of red meat or listen to the Rocky soundtrack. But whilst you can and should do both of those things, there is no substitution for preparation. Preparation comes in many forms. The first kind of preparation is knowing the papers inside and out. Do you remember back to those days in school or university where you were having a back and forth with a teacher or a supervisor? That tended to go much better, didn't it, when you knew the papers, you'd read the textbook and you knew your stuff. Spoiler, that was no coincidence. What was true for Henry VII's foreign policy is also true for a good cross-examination. If you know the material, you will know when the witness is telling you a porky and has given an incorrect answer. You also know when the witness is on shaky ground, when they're on firm ground, so when you need to press on or when you need to move on. Preparation is also important because it enables you to establish authority over the witness. You've got to say to the witness, you won't get anything past me. So I had a coffee with Mr. Jones and we discussed the takeover on the 24th of June. No, you didn't. The meeting was on the 28th and you had a chai latte. I've got the receipt. We know this. The witness is likely to think, cripes, this guy knows their stuff. I'm not going to get anything past them. That's the first kind of preparation. The other kind of preparation involves a case overview. It's more strategic. You need to step back and ask yourself, what do I need to achieve with this witness? How is this cross-examination going to help me win the case? Several elements to this. One, what can I get this witness to say or to admit that would be helpful to my case? Two, which bits of this witness's evidence do I need to challenge? Challenging. There's a few things to say about challenging a witness's evidence. You obviously have to challenge those bits of the witness's evidence that are harmful to your case and which you are saying is wrong. But at the same time, there will be other peripheral points of less relevance. Do you and should you challenge those? You need to exercise your judgment here. A bit of point scoring with a witness can be a good thing. As I mentioned earlier, it enables you to establish your authority. It also enables you to send a message across to the tribunal that their statement, their evidence is generally unreliable. But be careful about doing too much of this. Firstly, it wastes time. Any cross-examination, you only have a limited amount of time to play with, and they always take much longer than you think you're going to. So ask yourself, why am I challenging this? What am I hoping to achieve from this? Flowing from the waste of time point, there's also a risk of alienating the tribunal. The tribunal may just think, where's all this going? Is it really relevant? Whether it happened on phone, by email, whatever? What's the point of this? The other point to note in this regard is you risk losing control of the witness. You create opportunities for them to say something harmful if you ask unnecessary questions. Keep a witness on a tight leash. Restrict what they can or cannot say. That's always one of the keys to a good cross-examination. So, you've done your preparation. You've read the papers, you've worked out what exactly you want to ask to each witness. What's next? You need to prepare the questions. Be precise with your questions. Your questions should be tightly focused and leave no wriggle room. Now, don't be afraid to write your questions out in this regard, particularly when you get onto the really tricky and important points. The bar's littered with story of these legendary cross-examiners who went in with no notes or just an envelope and a few words on them and conducted a 3-day cross-examination. But mere mortals can't do that and really shouldn't even try to do that. Now, it's important to be flexible during cross-examination, a point I'm going to come back to. But whilst flexibility is a key element to a good cross-examination, at the same time you need to know where you're going and you need to know what your questions are on the key points. Also on questions, be short. Avoid multi-part questions where you can. The more moving parts there are to a question, the more likely it is a witness can wriggle out and avoid giving the answer you want them to give. Also, a judge may pay less attention to a helpful answer you get if the question is too long and the judge thinks the witness has been confused. Miss Forbes, if we assume for the purposes of this question that it was raining on Monday, you forgot your umbrella. As a result, when you got to the meeting, you were drenched. You didn't want the meeting to take too long, did you? You didn't want the resolution to be discussed for too long, so you just agreed to it after a short period of time. And as a result, on the next day, when you got the minutes, they were pretty short as well. You didn't spend much time reading them, did you? And so you just signed them off. That's true, isn't it? Can you repeat that, please? Any answer you get to a question like that is likely to be either, can you say that again, or so garbled as to achieve nothing in the grand scheme of things. Another of the golden rules you'll have heard about is never ask a question that you don't know the answer to. And that harks back to what I was saying earlier about the tight rein on the witness, keeping a leash on them. If you take a shot in the dark with no idea what the witness is going to say, you potentially lose control of the cross-examination and allow the witness to say damaging things. So it's a sound rule, but again, you've got to understand what it means and not treat it in absolute terms. If you think about it, nearly every question you ask in a cross-examination, you don't actually know what the witness is in fact going to say. What I understand the rule to mean is that you need to know the range of answers that the witness is going to give, and you have to have a response ready for each of the potential answers within that range. So let's take an example. You want to put to a witness that a particular document was signed at a meeting. And let's say if the answer is yes, that's helpful to your case. If the answer is no, that's unhelpful to your case. You genuinely don't know what answer the witness is going to give to this question. Can you ask the question, was the document signed? I would say yes, so long as you have material and follow-up questions prepared to demonstrate to the witness that they're wrong if you don't get the answer you want. You have to listen and stay flexible. You've got your questions, you've worked hours on them, they're beautiful. You're delivering them, but you're so focused on what the next question is, you're not hearing the answer. The answers often give valuable opportunities and valuable lines of follow-up questions that if you're too busy looking down at your notes, you're going to miss. Now, this is really hard. It's one of the hardest things about a cross-examination. You're in the moment and you have to all at once listen to the answer, assimilate it, work out what it means in the context of your case, look at the notes, work out if you're going to go on to the next question, work out if you need to go off-piste, and you have to do this all in a smooth moment so you move effortlessly from the answer to your next question. It is tricky, there's no bones about it, but if you don't listen, you're going to miss opportunities. Now, let's talk about the dream scenario. You get the answer you're looking for. You've asked the question and they've said what you want them to. Yes, we've done it, we've done it. No one else appears to be excited. The judge is unmoved, bored. Your opponent doesn't appear to be crying as they should be. Maybe they didn't appreciate the significance of the answer you just got. I know what I'm going to do. I'm going to get the witness to say it again for emphasis. It'll also be good to lord it over the witness, to let them fire another bullet into their foot. No! Once you've got the answer you're looking for, move on. A judge has said not so long ago that it's often thought by non-lawyers that good cross-examination consists of confronting the witness repeatedly and rubbing their nose in the answer. However, in truth, a good cross-examination consists of getting the answer you want for the purposes of closing submissions and moving swiftly on before the witness can start to dig themselves out of the hole. Well, amen to that. And that's how you cross-examine a witness.